Subcommittee will come to order. Chair recognizes himself for the purpose of an opening statement. And I do want to welcome everyone to the subcommittee markup for the Targeting Rogue and Opaque Letters Act of 2015. We certainly continue to hear from a wide variety of industries that patent demand letters are a major problem. All sides of the issue believe that congressional action is an important undertaking. Finding a way forward is not necessarily easy, but it is doable. A patent is a property right bestowed by the federal government pursuant to Article 1, Section 8 of the Constitution. Any limits on patent demand letters are then limits on the First Amendment free speech rights with respect to a right conferred by the government. Patent rights are constitutionally protected and federally conferred. Patents, therefore, do come with the right to notify others of their existence. Ultimately, we must insist on respecting the constitutional rights of patent holders. And in doing so, we vote today on a proposal that provides a constitutionally permissible avenue for consumer protection. Not only are these constitutional issues necessary to protect patent ownership, ignoring them risks leaving consumers exposed to judicial uncertainty and reversal. So caution is prudent when we try to introduce the Federal Trade Commission and state attorneys general, who are not themselves patent experts, into determining what patent holders can and cannot say. I was just at the Federal Trade Commission earlier this week talking about a number of issues. I certainly want to thank the Federal Trade Commission for their work on the MPHJ Technologies case. But there was also talk about how, given the breadth and broadness of many patents, it is difficult to find culpability in many demand letters. Patent breadth or broadness is not an issue that can be addressed through either the Federal Trade Commission or the State Attorney General's offices. What we can try to do is identify baseless threats and deceptive acts in letters and provide civil penalties where it is clear that abusive patent holders intentionally violated those acts. The Federal Trade Commission today has certain minimum knowledge requirements in order to impose civil penalties, and I believe the Targeting Rogue and Opaque Letters Act will be consistent in that regard. And civil penalty authority is significant. MPHJ was the essential TROL, and even in that case, the Federal Trade Commission could not bring an action for civil penalties. The Federal Trade Commission had evidence that through 81 companies, MPHJ had sent over 31,000 deceptive demand letters across the country. The strongest enforcement tool available to the Federal Trade Commission was a settlement barring MPHJ from making deceptive representations when asserting patent rights in the future. This act under consideration today gives the Federal Trade Commission and the State Attorneys General the authority to go straight to civil penalties for bad faith demand letters. This is clearly a stronger position than under current law. This bill also identifies certain basic information that must be included in a demand letter so that letter recipients have a starting place to determine if the sender is indeed legitimate. There may be some ability to do more in this space with limited claim information. We may also be able to lower the burden of proof for penalties around disclosure in some instances, and we certainly hope that all interested parties will continue to work with us on these issues. Not only do we empower state attorneys general to enforce provisions of this legislation, the bill preserves the ability to enforce their state consumer protection laws of general applicability. We are also preserving the Federal Trade Commission's ability to bring cases under its Section 5 Unfair and Deceptive Acts or Practices Authority in deceptive demand letter cases that fall outside the scope of bad acts covered in the bill. We have heard concerns about the affirmative defense in the bill. We will offer an amendment today to mirror the language it was in the Fair Debt Collection Practices Act for bona fide mistakes, as was suggested by the minority witness in last week's hearing. There is no doubt that abusive patent demand letters can wreak havoc on small businesses and drive up costs for consumers. I hope that more stakeholders will work with us within the confines of what we can do constitutionally to provide additional avenues of enforcement. On that note, I want to thank stakeholders who have persisted and worked with us on the legislative process. The door, of course, remains open as we continue to move forward. I hope that we can do so together as opposed to splintering off and dividing at a crucial time. With an eye towards protecting small businesses and consumers within the Constitution, I hope my colleagues will join me in advancing this bill today. I yield back my time and recognize the gentlelady from Illinois, Ms. Schakowsky, 5 minutes for the purpose of an opening statement.
Thank you very much, Mr. Chairman. We all understand that patent trolls threaten consumers and businesses all across the country. They extract settlements in the thousands of dollars from businesses that can't afford to go to court. Worse still is the fact that trolls have no legitimate patent infringement claim. It costs patent trolls virtually nothing to send patent demand letters, but they have cost American businesses literally tens of billions of dollars in the past few years. I'm interested, as I know the chairman is, in finding a solution to this problem that protects businesses and consumers against patent trolls, and that solution must also recognize the legitimate rights of patent holders to protect their ideas and technology. I appreciate the bill's attempt to balance those two priorities. It's not easy work, and unfortunately, as is, I think the bill misses the mark. There are two major loopholes that essentially make the bill unenforceable and enable patent trolls to continue operating uninterrupted. They must both be addressed in order for this legislation to truly curb deceptive patent assertion entities. First, excuse me. This bill requires the Federal Trade Commission to prove bad faith of the sender in order for patent demand letters to be considered an unfair or deceptive act or practice. In short, this means that the FTC has to be able to prove that the sender of a patent demand letter knowingly made false statements or was aware that the recipient would be deceived. That's virtually impossible to prove, meaning victims will be left in the same position they are today. Second, the bill's affirmative defense clause presents major problems. Basically, this provision means that if a patent assertion entity in the regular course of business sends any regular written communication that does not violate the provision of the bill, then they're not in violation of the law. So unless you troll 100% of the time, you're not considered a troll, and that's kind of crazy. And any business that currently trolls 100% of the time can easily modify their behavior to avoid liability. If this law passes, this eliminates any consumer protections this bill would otherwise guarantee. And I understand, I hope I'm right, that the majority plans to offer amendments to partially address these two issues, and I genuinely appreciate their willingness to improve the bill. Nonetheless, there are other serious problems with the TROL Act. The TROL Act sets arbitrary caps on penalties for unfair, deceptive patent assertions. I believe that the punishment should always fit the crime, and that the scope of the crime and the ability to pay should be considered in determining fines for violations of this Act. There should not be a cap on liability for the sake of a cap. This bill also preempts 20 existing state laws that hold patent trolls accountable, including one in my home state of Illinois. In many ways, these state protections exceed those that would be guaranteed under the TROL Act. We should not preempt state laws with a weaker federal standard. I look forward very much to working to improve this legislation to make sure that it adequately addresses the issue of patent trolls. And with that, Mr. Chairman, I yield back.
Chair thanks the gentlelady. The gentlelady yields back. The chair now recognizes the vice chair of the full committee, the gentlelady from Tennessee, Ms. Blackburn, 5 minutes.
Thank you, Mr. Chairman. Those of us that have innovators in our districts hear from them fairly regularly about demand letters that come from patent trolls. These are really a thorn in the side of these innovative new start businesses and new start concepts. And it is a practice that really does cost our economy billions of dollars per year because of the uncertainty that it interjects into the system. So, the TROL Act, Targeting Rogue and Opaque Letters Act, would crack down on patent trolls by zeroing in on these persons who engage in a pattern of practice of sending demand letters and who act in bad faith when communicating or failing to communicate information within such correspondence. Violations under the TROL Act will be treated as an unfair and deceptive practice act. It is enforceable by the FTC. The act will preempt state laws. State attorneys generals will still have a mechanism by which they can enforce the act and seek civil penalties. So, Mr. Chairman, good work on bringing this forward, and we appreciate the way you have continued to work to address this issue that affects so many of our constituents. And with that, I yield back the balance of my time.
Chair thanks the gentlelady. The gentlelady yields back. The chair now recognizes the gentleman from New Jersey. 5 minutes for an opening statement, sir.
Thank you, Mr. Chairman. Today, the subcommittee will be marking up Chairman Burgess's draft bill on patent demand letters. The patent system plays a crucial role in the economy by promoting innovation. Yet we've heard that some businesses, commonly known as patent trolls, have been taking advantage of the patent system using abusive patent demand letters. The recipients of these letters are often small Main Street businesses like coffee shops, realtors, hotels, and restaurants. The purpose of the bill before us is to encourage targeted enforcement and ultimately stop such abusive tactics by patent trolls. I could support demand letter legislation that advances consumer protection, but I can't support this bill, which I believe creates a disincentive to enforcement by tying the hands of state attorney generals and by creating barriers to the FTC enforcement that are simply too high. Some state attorneys general have taken legal action to protect their citizens from unfair and deceptive demand letters. In addition, 20 states have already enacted legislation to tackle this abusive activity. This bill would completely preempt the 20 laws that expressly address abusive patent assertion communications. It also severely constrains states' abilities to take an active role by limiting available remedies and placing an arbitrary cap on civil penalties. Just like with the data breach bill, if Congress seeks to preempt specific state laws, especially on issues on which the states have been leaders fighting unfair and deceptive acts, such as false and misleading demand letters, the federal effort should be at least as strong as those state laws. Moreover, the bill would place a number of additional burdens on enforcers at both the state and federal levels, particularly by requiring proof that the sender knew that representations in the letter were false or misleading. This knowledge requirement is an unusual element that would make investigation and enforcement far more difficult. The FTC staff in comments on this draft explained, and I quote, "Consumers can be harmed by misrepresentations regardless of whether the party making the representations knows them to be false." The staff further stated that proving knowledge would be a significant and counterproductive departure from existing law. Furthermore, the affirmative defense in the draft creates a loophole so large it could completely eliminate liability for unfair or deceptive demand letters, creating yet another barrier to enforcement. So, Mr. Chairman, I will support efforts to ensure that states and the FTC continue to be able to enforce against fraudulent actors and are able to collect civil penalties from wrongdoers. However, I cannot support the bill before us today without some significant changes. So let's work together to craft legislation that will protect the rights of patent holders while ensuring the appropriate tools exist to enforce against abusive practices. I yield back, Mr. Chairman. Thank you.
Chair thanks the gentleman. The gentleman yields back. The chair reminds members that pursuant to committee rules, all members' opening statements will be made part of the record. Are there further opening statements on the majority side? Are there further opening statements on the minority side? Seeing none, the chair then calls up to committee print and asks the clerk to report.
Discussion draft. To provide that certain bad faith communications in connection with the assertion of a United States patent are unfair, deceptive acts or practices, and for other purposes.
Without objection, the first reading of the bill is dispensed with, and the bill will be open for amendment at any point. So ordered. Are there bipartisan amendments to the bill? Seeing none, we'll consider other amendments, and the chair will recognize himself for the purposes of offering an amendment. Manager's Amendment 1.
Amendment to the discussion draft offered by Mr. Burgess.
Recognize myself for 5. Without objection, the hearing of the amendment is dispensed with, and I'll recognize myself for 5 minutes in support of the amendment. This amendment would replace the affirmative defense in the base draft bill with a more narrow approach. And the reason we're making this change is straightforward. Some stakeholders have worried that the affirmative defense in the base draft would create a loophole for bad behavior. For example, some worried that a bad actor could benefit from the affirmative defense simply by establishing a record of good behavior before embarking upon bad behavior. So we adopted a suggestion that was brought to us by the minority witness at our legislative hearing last week from public knowledge to use the bona fide error defense in the Fair Debt Collection Practices Act. Specifically, the amendment would provide an affirmative defense is available if the defendant can show by a preponderance of the evidence that a violation was not intentional and resulted from a bona fide error notwithstanding the maintenance of procedures reasonably adapted to avoid such error. I understand that many would like to remove the affirmative defense altogether, but I believe this amendment provides a good compromise. And I will yield back and ask if there are others who wish to speak on the amendment. Chair recognizes the gentlelady. Or, well, for what purpose does the gentlelady seek recognition?
To strike the last word.
The gentlelady is recognized for 5 minutes.
I will not take 5 minutes. I support this amendment. It makes the bill better, changes the affirmative defense provision to require more evidence that patent demand letters that violate this act are sent in error. I think that is a helpful change. I don't think there needs to be an affirmative defense, but if there is, this is a sensible way to address the issue. I plan to vote for this amendment, but just wanted to indicate that I still find the underlying bill problematic, but I will certainly support this amendment. I yield back.
Is there other discussion on the amendment? If there's no further discussion, the vote then occurs on the amendment. All those in favor shall signify by saying aye. Aye. All those opposed, nay. The ayes appear to have it. The ayes have it, and the amendment is agreed to. Other amendments? Are there other amendments that would like to be offered?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
159. 164.
Amendment to the discussion draft offered by Ms. Schakowsky.
Without objection, the reading of the amendment is dispensed with, and the gentlelady is recognized for 5 minutes in support of the amendment.
I believe that the TROL Act, unfortunately, has a number of fatal flaws, and the amendment I'm offering fixes those flaws and strikes the right balance between protecting the targets of unfair and deceptive demand letters and the rights of legitimate patent holders. Under this amendment, the FTC is directed to issue rules that prohibit the sending of unfair and deceptive demand letters. The rules would take into account the list of false or misleading representations and omissions included in the draft bill as a guide for those regulations. This rulemaking would provide certainty to the senders of demand letters and would give the Federal Trade Commission the enforcement flexibility necessary to combat abusive letters. Recognizing that states are the leaders in protecting the targets of unfair and deceptive demand letters, this amendment also gives state attorneys general the ability to effectively enforce the law and brings a federal standard to the 30 states that do not have laws on patent demand letters. It also allows states to continue their ongoing efforts to combat abusive demand letters through the state laws already on the books, as well as through general consumer protection laws and common law. Many of the businesses that have been targets of unfair and deceptive demand letters have expressed their concern that the TROL Act, as currently drafted, will discourage enforcement because of the many obstacles that it creates for the state attorneys general and the FTC. This amendment removes those barriers to enforcement by removing the pattern or practice requirement, the bad faith requirement, and the unnecessary and overly broad affirmative defense provision. A bill that can never realistically be enforced is not useful. This amendment threads the needle to combat unfair and deceptive demand letters while avoiding catching legitimate patent holders in the net. I would urge my colleagues to support this amendment. And I could yield to someone, or shall I? You have more than, okay. I yield to the chairman of the ranking member of the full committee.
Thank you, and I want to support Ms. Schakowsky's amendment. The amendment makes several improvements by strengthening the FTC, removing barriers to enforcement, and preserving the power of the states to address patent demand letter abuses. The FTC has significant expertise with regard to unfair and deceptive acts over many years, and I strongly support giving the agency the relevant rulemaking authority to prohibit the ending of unfair and deceptive demand letters. Furthermore, the elimination of the affirmative defense and bad faith and pattern of practice requirements is a much-needed improvement that would plug any loopholes created as a result of the bill's overly broad language. As we heard during last week's legislative hearing, abusive patent assertion entities may be engaged in abusive behavior despite not having a prior record of abuse. I'm also pleased that the amendment includes a no preemption clause that preserves the growing number of state laws intended to curb abusive patent demand letters, as well as a provision to ensure that state attorney generals are able to assert a state law claim in a civil action. So I urge my colleagues to support this amendment and yield back to the gentlewoman.
And I yield back. Thank you.
Chair thanks the gentlelady. The gentlelady yields back. The chair then recognizes himself to strike the requisite number of words and will recognize myself for 5 minutes to speak against the Federal Trade Commission having rulemaking authority. You know, protecting small businesses from bad faith demand letters is not an area where Congress should delegate its authority to the Federal Trade Commission, when in fact we can clearly delineate what constitutes a bad faith demand letter in legislation. The committee has developed an extensive record, or the subcommittee has developed an extensive record clearly documenting the problem that bad faith demand letters create for small and medium-sized businesses across the country. There is no need to grant the Federal Trade Commission rulemaking authority to flesh out those details further. This act gives the Federal Trade Commission additional tools to go after bad faith demand letters and protects those good faith actors asserting their rights within the four corners of the bill. Granting the Federal Trade Commission rulemaking authority in this area delegates Congress's authority unnecessarily. Yes, in the past, Congress has granted the Federal Trade Commission limited Administrative Procedures Act rulemaking authority, but those have been limited to instances where all sides have agreed that there are pieces of an issue that need to be filled in by the Federal Trade Commission through the rulemaking process. That is not the case with this issue. Additionally, granting the Federal Trade Commission rulemaking authority will only further delay civil penalty actions against entities sending out bad faith demand letters. The political reality is that the Federal Trade Commission rulemaking authority in this area is not viable, and we should act to help the businesses harmed by bad faith demand letters sooner rather than later. And I would be happy to yield to others on the majority side. The chair yields to Mr. Lance.
Thank you, Mr. Chairman. I speak on my belief in a strong preemption, and I think that is important for this legislation. A patchwork of state laws is not, in my judgment, the most effective way to address the issue of patent trolls who are sending letters nationwide. The appropriate way to address this issue is at the federal level and to set one national standard that is enforced by the FTC and by state attorneys general. We are talking about a federally conferred right created by the Constitution of the United States. The effectiveness of existing state laws is still unclear. It is very possible that the federal courts will find that states are preempted from acting in this space as a result of the Noor-Pennington doctrine. And if this were to happen, it would leave states only able to act in the event of sham litigation, which only applies if the patent assertion is objectively baseless. This is an extremely high burden to carry and was rejected as a standard by both the FTC and the recipient community very early in our negotiations. 50 state laws with different court interpretations will add expense and complications to an already complicated field and hurt innovation. Moreover, mistakes, innocent technical mistakes, will inevitably be made, adding additional costs. I believe that setting a single national standard will ensure that we act to stop patent trolls, and we're not adding to the compliance burden or confusion for businesses, and I yield back to you, Mr. Chairman.
Chair thanks the gentleman. The chair yields back the balance of the time. Other members seeking time on the amendment? Seeing none, if there's no further discussion, the vote occurs on the amendment. All those in favor shall signify by saying aye.
Aye.
All those opposed, nay. Nay.
I'd like a roll call vote.
The ayes have it. The amendment is not agreed to. The gentlelady requests a roll call vote. The clerk will call a roll.
Mr. Lance? No. Mr. Lance votes no. Mrs. Blackburn? Mrs. Blackburn votes no. Mr. Harper? No. Mr. Harper votes no. Mr. Guthrie? No. Mr. Guthrie votes no. Mr. Olson? Mr. Pompeo? Mr. Kinzinger? No. Mr. Kinzinger votes no. Mr. Bilirakis? No. Mr. Bilirakis votes no. Mrs. Brooks? Mrs. Brooks votes no. Mr. Mullen? No. Mr. Mullen votes no. Chairman Upton? No. Chairman Upton votes no. Ms. Schakowsky?
Aye.
Ms. Schakowsky votes aye. Ms. Clark?
Aye.
Ms. Clark votes aye. Mr. Kennedy? Aye. Mr. Kennedy votes aye. Mr. Cardenas? Aye. Mr. Cardenas votes aye. Mr. Rush? Aye. Mr. Rush votes aye. Mr. Butterfield? Mr. Welch? Yes. Mr. Welch votes aye. Mr. Pallone? Aye. Mr. Pallone votes aye. Chairman Burgess?
No.
Chairman Burgess votes no.
Are there other members seeking to be recorded? If not, the clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 10 nays.
The amendment is not agreed to. Chair recognizes himself for purposes of striking the requisite number of words and to offer an amendment. This is Manager's Amendment number 2. And just for planning purposes, this amendment will be withdrawn at the conclusion of its offering. Clerk will report.
Amendment to the discussion draft offered by Mr. Burgess.
Chair recognizes himself for 5 minutes to speak on the amendment. There are some concerns regarding the draft legislation that the Federal Trade Commission will have difficulty in proving bad faith. I believe the bad faith definition does strike a good balance in protecting legitimate patent assertions, avoiding enforcement actions for mistakes, while ensuring that the bad actors are indeed held accountable. However, I am offering and then withdrawing this amendment to show that we are willing to lower the bar to enforcement cases where senders of demand letters don't provide meaningful information. This amendment would provide a presumption that the sender of a demand letter acted in bad faith in cases where the recipient asked for certain information and the sender failed to supply it within a reasonable time frame. The amendment also provides that a demand letter recipient can ask for a patent claim at issue, and if one is not provided, a presumption of bad faith may be triggered. The language is not finalized. It is a work in progress, and we hope that stakeholders will be willing to continue to work with us. We do hope to get a compromise position so that this bill has the right balance, and certainly look forward to working with everyone on this provision as we go forward. I would be happy to yield time to any member seeking recognition. Chair recognizes the gentlelady.
Thank you for the time, Mr. Chairman. I look forward to working with you. I think this amendment was moving in the right direction, and I am hoping that we can come to an agreement on an amendment we can all support. And I don't know if anyone else wants time. Okay.
Very well. The gentlelady yields back, and I'll yield back the balance of the time. Any further discussion on the amendment? The chair will withdraw the amendment. Further amendments on the bill? For what purposes the gentleman from Massachusetts seek recognition?
Thank you, Mr. Chairman. Move to strike the last word. No amendment to this. Excuse me.
Clerk will report.
What is the title?
It's COMB 02.
Amendment to the discussion draft offered by Mr. Kennedy.
The gentleman is recognized for 5 minutes on his amendment.
Thank Thank you, Mr. Chairman. I won't take all that time. Mr. Chairman, I appreciate your efforts to make this bill stronger. I do believe it still needs some significant improvements before I can support it. The amendment makes changes that remove the barriers to enforcement currently in the bill. If we intend to pass a bill that effectively combats unfair and deceptive patent demand letters, we must ensure that the enforcers are properly equipped with the necessary and that the necessary obstacles are removed. First, this amendment removes the pattern or practice requirement. In addition to being ambiguous, it requires the FTC or state attorneys general to investigate and provide evidence of multiple letters from the same sender. Because patent trolls send letters privately and often hide their identities, this can be an extremely difficult barrier, which is likely why none of the 20 state laws include a pattern or practice requirement. This amendment also removes the bad faith requirement. Bad faith standard will require enforcers to prove the state of mind of the sender of the unfair or deceptive letters, which is a highly unusual requirement in consumer protection cases. Regulation of unfair and deceptive demand letters is a run-of-the-mill for FTC and state attorneys general. This does not require specialization in patent law. The bad faith requirement is potentially an insurmountable barrier to enforcement. Similarly, this amendment removes the affirmative defense language and clause. And, Mr. Chairman, while I appreciate the amendment that you adopted and authored to try to find an accommodation here, I still believe that it's unnecessary to protect good actors, and it would be this clause, as amended, could easily be exploited by bad actors. Finally, this bill corrects a conflict in the preemption language. It is clear that the intent of this preemption language is to limit the preemption only to state laws that explicitly address abusive patent demand letters. The savings clause is clearly intended to preserve state common law and the state's general consumer protection laws. The correction made by this amendment simply clarifies that intent. The changes made by this amendment, Mr. Chairman, reflect the minimum that needs to be done to make this bill more effective to protect targets from unfair, deceptive patent demand letters. I urge my colleagues to support it. Thank you. I yield back.
Chair, thanks. The gentleman yields back. The chair will recognize himself for the purposes of striking the requisite number of words and recognize myself for 5 minutes to speak against the amendment. Look, there is a concrete, defined harm before us today. We should not legislate to address hypothetical problems like one-off demand letters. The business model we have heard about over and over does not include one-off letters. We should address the harms that are clearly in front of us. The actual language of the bill states that, quote, it shall be an unfair or deceptive act or practice to engage in a pattern or practice of sending written communications that state or represent that the recipients are or may be infringing or may have infringed the patent and bear liability and owe compensation to another, close quote. It goes on to list the prohibited misrepresentations and the disclosure that the sender must make in a demand letter. The entire business model that we've been hearing about for years is that a patent assertion entity will send hundreds or thousands of demand letters to relatively unsophisticated businesses hoping to extort a licensing fee and calculate it to come in just below the cost of litigation without having to do much more than hit the send button or stuff some mail in envelopes. In fact, this subcommittee has received multiple examples of these demand letters from the recipient community, and not one was submitted as an example of a one-off demand letter. They are all part of larger campaigns. This act would explicitly grant the Federal Trade Commission civil penalty authority to go after those bad actors for the 12 misrepresentations listed in the bill and the 5 required disclosures. This is a major improvement from the status quo, and removing the pattern or practice, as this amendment suggests, will not move the ball forward toward final passage. And the chair would be happy to recognize other members on the majority side who wish to speak. The chair recognizes the gentleman from Mississippi.
Thank you, Mr. Chairman. I also speak in opposition to this amendment. I think the remedies we provide for state attorneys general are sufficient under the draft legislation, and we provide civil penalties up to $5 million and injunctions. Moreover, we authorize the state attorney general to bring an action under the Act. Action by a state AG should be sufficient to protect the interests of the state, and there's no reason to enable private enforcement of a harm that affects the interests of a state. The state AG is the proper enforcer for the Act when a state interest is affected by abusive demand letters, not private litigation firms. We use the same construct as is currently used in the Sherman Antitrust Act. State attorneys general have robust enforcement programs under the Sherman Act. The language we use, which invokes the interest of the state, ensures that the state AGs have standing to sue under the Act. We know this because the language has worked in the Sherman Act context. Other language constructs are less certain, so the preferred language is what we currently have in the draft text. And I yield back, Mr. Chairman.
Gentleman yields back. Chair will yield back the time. Is there further discussion on the amendment? Chair recognizes the gentlelady from Illinois.
Thank you, Mr. Chairman.
For what purpose does the gentlelady from Illinois speak?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you. This amendment addresses many of the concerns I and others have with the legislation. And since the previous Democratic amendment, which I offered, did not pass, I hope my colleagues will support this narrowly tailored approach. This amendment addresses the two glaringly obvious problems with the bill, the bad faith and affirmative defense provisions. The bad faith requirement calls for an understanding of the knowledge and intent of a patent assertion entity at the time a demand letter is sent. The affirmative defense provision states that as long as letters do not violate this act, are sent in the regular course of business, no letters. Well, everyone knows what that is. And I know that we just passed an amendment that I think does improve the bill. But it seems to me that if we truly want to address the issues with patent demand letters, these provisions should be scrapped, and that's what this amendment does. The amendment also addresses less noticeable but still important problems with the bill. It eliminates the requirement that a pattern or practice of sending demand letters that violate this act be established in order to go after bad actors. And, Mr. Chairman, I think that we certainly want first-time offenders, too, to be caught under this, even though there may not be a long history. But if they just start to get into the business of sending demand letters, yes, I realize we're not talking about one-off letters, but we certainly want to make sure that we capture everyone. And as Mr. Kennedy pointed out, that can be virtually impossible to show that the pattern or practice, especially for a first offense, given the nature of the letters and the businesses and individuals that they target. And this amendment removes barriers to enforcement of state small businesses and consumer protection statutes as well as common law. We should maximize existing protections against patent demand letter abuse. So again, I support the amendment. It's narrowly drafted. I urge my colleagues to support it. And I yield to the gentleman from New Jersey.
I thank the gentlewoman. I just want to say the Kennedy Amendment is another worthy attempt to correct some of the shortcomings of the underlying bill, specifically when it comes to barriers to enforcement and state law preemption. Like the Schakowsky Amendment, the Kennedy Amendment also strikes the bad faith requirement, a highly unusual standard that adds an unnecessary hurdle to law enforcement when pursuing patent trolls. And the Kennedy Amendment also removes the affirmative defense clause, which serves no other purpose than to shield bad actors from liability. By passing this amendment, we would close a gaping loophole in the underlying bill that currently allows senders of patent demand letters to demonstrate good faith through previous written communications that do not violate the provisions of the Act or simply through other evidence. Additionally, while this amendment does not remove the preemption of the 20 state laws already passed targeting abusive patent demand letters, it does ensure that states have the ability to appropriately punish bad actors and ensures that state consumer protection and common laws are not preempted. So I would urge my colleagues to support the Kennedy Amendment and yield back to the gentlewoman.
Is there anyone who would like to speak in favor of the amendment on our side? Then I yield back.
Chair thanks the gentlelady. Gentlelady yields back. Other members seeking recognition on the amendment? If not, the vote occurs on the amendment. All those in favor will say aye. Aye. All those opposed, nay. Nay.
We'd like a roll call.
The gentlelady requests a roll call vote. The clerk will call a roll.
Mr. Lance. Mr. Lance votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Harper. Mr. Harper votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Chairman Upton. Chairman Upton votes no. Ms. Schakowsky. Ms. Schakowsky votes yes. Ms. Clark votes yes. Ms. Clark votes yes. Mr. Kennedy. Mr. Kennedy votes yes. Mr. Cardenas. Mr. Cardenas votes yes. Mr. Rush. Mr. Rush votes yes. Mr. Butterfield. Mr. Welch. Mr. Welch votes yes. Mr. Pallone. Mr. Pallone votes yes. Chairman Burgess. Chairman Burgess votes no.
The clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 10 nays.
And the amendment is not agreed to. Are there members seeking recognition for further amendments? If there are no members seeking further amendments, the question now occurs on forwarding the committee print as amended to the full committee. All those in favor will say aye. Aye. All those opposed, nay.
No.
The ayes appear to have it. The ayes have it. The bill is favorably forwarded.
Like a roll call?
The gentlelady requests a roll call vote. The clerk will call the roll.
Mr. Lance. Yes. Mr. Lance votes aye. Mrs. Blackburn. Mrs. Blackburn votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Bilirakis. Mr. Bilirakis votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Chairman Upton. Chairman Upton votes aye. Ms. Schakowsky. Ms. Schakowsky votes no. Ms. Clark. Ms. Clark votes no. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas. Mr. Cardenas votes no. Mr. Rush. Mr. Rush votes no. Mr. Butterfield. Mr. Welch. Mr. Welch votes no. Mr. Pallone. Mr. Pallone votes no. Chairman Burgess. Chairman Burgess votes aye.
Vote.
Mr. Chairman, on that vote there were 10 ayes and 7 nays.
The ayes have it, and the bill is agreed to. Without objection, the staff is authorized to make technical and conforming changes to the legislation approved by the subcommittee today, so ordered. Without objection, the subcommittee stands adjourned.